New reporting here after that unprecedented FBI search at the home of former President Trump at Mar-a-Lago in Florida. Tonight, ABC News has learned that the FBI told the Secret Service just 45 minutes before they arrived, and then the Secret Service telling Mar-a-Lago staff just moments before those agents arrived. Sources telling ABC News the search is related to allegations the former president improperly removed documents when he left the White House. They were brought to Mar-a-Lago, including classified material. And it wasn't the first time federal agents had been to Mar-a-Lago, their first visit in the spring. We have learned tonight that it was a staff member at Mar-a-Lago who called Eric Trump, and Eric Trump who then called his father to tell him about the search. The former president was in New York, seen leaving Trump Tower last night, and tonight here the first words from the former president while calling into a political event, saying, "Another day in paradise. This is a strange day."
Hey guys, Adam speaking. This happening right now. New York's Attorney General has already set the legal machinery in motion to potentially seize Mar-a-Lago, and it traces back to a decision Trump made decades ago that may have accidentally stripped away the legal protection that would have kept his most prized property safe.
This morning, we are learning more about exactly what was seized from former President Trump's Mar-a-Lago estate. At least 24 FBI agents executed the search, and a total of 27 boxes were taken. In them, 11 sets of classified documents, including some that are top secret. The FBI also removed binders of photos, a handwritten note, the executive grant of clemency for Roger Stone, and information about the President of France. The court filing shows investigators had probable cause to search the estate related to 3 federal laws, including violations of the Espionage Act.
So stop whatever you're doing, because what I'm about to walk you through is the actual paper trail, the court filings, the county clerk records, the legal commentary from analysts who have been tracking this since day one. The path from civil judgment to federal marshals at the gate is not some imaginary slippery slope. It is a clearly defined sequence of legal steps, and several of those steps have already been completed.
Sources tell ABC News the Department of Justice had started a grand jury investigation in May about alleged mishandling of classified information. Tonight, heavily armed Secret Service agents stand guard at the gates of Mar-a-Lago, and this evening, former President Trump issuing a new statement calling the search a horrible thing. Dan Abrams is standing by on this, but we begin tonight with our chief Washington correspondent, Jonathan Karl, leading us off.
We're learning new details about the FBI's extraordinary raid on Donald Trump's Mar-a-Lago property in Palm Beach. Law enforcement sources tell ABC News that 45 minutes before the FBI showed up, the local FBI field office in Miami gave the Secret Service team in Mar-a-Lago a heads up. The sources say the Secret Service agents did not notify anybody on the Mar-a-Lago staff until just as the FBI agents were arriving. When they did arrive, the FBI agents were escorted into the property by the Secret Service. Sources close to Trump say the club's general manager then placed a call to Eric Trump, who alerted his father. Neither Trump nor any members of his family were there at the time.
The only questions left are timing and whether Trump can somehow come up with the cash before the machinery reaches its inevitable endpoint. Let's start with the hard numbers, because the scale here is what makes all of this so urgent. After the civil fraud ruling in New York, Trump was hit with a judgment hovering around $454 million. Add interest, and you're looking at roughly $464 million. That is the baseline. And every single day that passes without that judgment being satisfied, the total grows by more than $100,000. That is not a typo. Over $100,000 per day in interest alone. A judgment that started at $454 million pushes past $500 million in a matter of months. This is the ticking clock that makes every other part of this story move with such high stakes. Now, here is where the legal machinery comes into focus. Back in early 2024, Letitia James filed judgments in Westchester County. Why Westchester? Because that is where Trump owns Seven Springs Estate and Trump National Golf Club Westchester. Legal analysts at the time called this the first clear indication that the state was preparing to seize those properties. And let me be very specific about what that filing actually means. Entering judgment in a county is not a warning shot. It is not a threat. It is the formal legal step that creates a recorded lien against those named properties. It is the paperwork that establishes the state's secured claim. That step is already done. The liens exist. They are sitting in county records right now. But James didn't stop there. The judgment has also been docketed in New York City, where Trump Tower sits, where his penthouse sits, where multiple other properties across the Manhattan skyline form the commercial backbone of the Trump organization. And here is where it gets even more explosive. Court documents have explicitly listed Mar-a-Lago among the properties that could become targets if Trump cannot produce the cash to satisfy the judgment. Let that sink in for a moment. The state has already put Mar-a-Lago on notice. The property is named, it is documented, it is part of the official legal record as a potential enforcement target. So let's pause here and understand exactly where we stand in the sequence. Step 1. The civil judgment itself. That is complete. Step 2. Docketing that judgment in specific counties to create liens. That is complete for Westchester and New York City. Step 3. Obtaining a writ of execution from the court. That is the formal order directing law enforcement to go seize specific assets. That step has not been taken yet because of the bond Trump posted and because the appeals process is still active. Step 4. The actual enforcement. Marshals or sheriffs arriving at the properties, tagging assets, cataloging them, preparing for auction. That is the scenario everyone is watching for. And the machinery is already past Step 2. It is waiting on Step 3. Now, let's talk about Mar-a-Lago specifically, because this is where the story takes a turn that almost feels like something out of a legal drama. Florida has one of the strongest homestead protections in the country. If you live in Florida and a creditor comes after you, your primary residence is generally off limits. Period. That protection is so powerful that wealthy individuals have moved to Florida specifically to shield their homes from lawsuits and judgments. Under normal circumstances, Trump would be able to claim that protection for Mar-a-Lago. He calls it his home. He lives there. It is his primary residence. That should be the end of the story. But there is a wrinkle. And that wrinkle dates back to 1993. 3 decades ago, Trump made a deal with the town of Palm Beach to convert Mar-a-Lago from a private residence into a private club. That conversion came with conditions. Specific restrictions on how many days per year he could actually use the property as a residence. He accepted those restrictions because turning the property into a club made it more commercially valuable. It generated membership fees. It became a business asset. That decision made sense at the time. But now, 3 decades later, those same residential restrictions are the thing that could cost him the homestead protection. Legal experts have pointed to this exact scenario. A court could look at the 1993 agreement and determine that because of those restrictions, Mar-a-Lago's primary legal character is commercial, not residential. And if that happens, the homestead exemption disappears. The property that Trump calls his palace, his base of political operations, the place where he holds court with allies and supporters, becomes just another asset that creditors can seize. The irony is brutal. He made Mar-a-Lago more commercially valuable by accepting those residential restrictions, and that commercial value may now be exactly what makes it available to the people trying to collect on the judgment. Now let's zoom out and look at the broader picture, because Mar-a-Lago is not the only property in play. The Westchester properties already have liens recorded against them. Trump Tower in Manhattan has a lien against it, and here is where it gets even more complicated. Trump Tower carries a massive mortgage from Axos Bank. When you have a property with a judgment lien competing against a mortgage lender's security interest, you have a financial complexity that makes refinancing or selling the property much harder. The judgment lien has to be satisfied before the seller gets any proceeds. That means even if Trump wanted to sell Trump Tower to raise cash, the judgment would take first cut. The same logic applies to Seven Springs, to the Westchester Golf Club, to any other domestic property with a recorded lien. And the interest clock keeps running. Every day that passes, the total grows by over $100,000. That means the appeals process that Trump's team is relying on to reduce or reverse the judgment is simultaneously making the judgment larger. Every day of delay buys more time, but it also buys a bigger number. That is the trap. The normal strategy of dragging things out through appeals becomes a strategy of letting the obligation compound until it becomes almost impossible to satisfy through anything other than asset sales or enforcement. So what are the options? There are really only four. Pay the judgment in cash. That would require coming up with roughly $500 million, which is not a trivial amount even for someone with Trump's wealth. Refinance properties to pull out cash. That becomes harder when those properties already have judgment liens attached. Sell assets to generate cash. That also becomes harder when those assets have liens that must be satisfied from the sale proceeds before the seller sees a dime, or allow the enforcement process to continue toward the writ of execution and physical seizure. Those are the only paths, and each one carries its own financial and political consequences. Now let's bring this all together with 4 key points that should give you a complete picture of where things stand and where they are going. The Westchester filings are the most advanced enforcement step already taken. Those are not threats. Those are completed legal instruments. They have created recorded liens against Seven Springs and Trump National Golf Club Westchester. Those liens can be executed through foreclosure proceedings the moment the temporary enforcement stay lifts. The identification and lien recording work is already done. What remains is purely procedural. The 1993 private club reclassification is the single most important piece of the Mar-a-Lago story. It is the decision that could strip away the homestead protection that would otherwise shield the property. And it was made 3 decades ago for legitimate business reasons. The legal vulnerability was created long before the fraud judgment even existed. That timing is the specific irony that makes this so legally grounded and so politically explosive. The interest clock running at over $100,000 per day is the financial pressure mechanism that makes delay a losing strategy. Every day, the appeals process continues, the judgment grows. The strategy of buying time is also the strategy of letting the number get bigger. That compounding pressure changes the calculus for everyone involved. Here is what we need to watch going forward. Watch the appeals resolution. Whatever final number comes out of that process will establish the target Trump has to hit. Watch the bond situation. The temporary enforcement stay will expire when the appeals conclude, and what happens at that moment will determine whether James moves immediately to execution proceedings. And watch the Mar-a-Lago homestead litigation. If James eventually moves against the Florida property and Trump fights it on homestead grounds, the ruling on the 1993 reclassification question will be the moment that decides whether Florida's strongest asset protection tool shields or fails to shield Trump's most famous property. So here is the bottom line. Letitia James has already filed judgment liens against Trump's Westchester properties. The judgment has been docketed in New York City, creating liens against Trump Tower and other Manhattan assets. Court documents list Mar-a-Lago as a potential enforcement target. The 1993 private club reclassification is the specific vulnerability that could remove Florida homestead protection from Mar-a-Lago. The combined judgment totals could exceed $500 million, growing by over $100,000 per day. Marshals are not at the Mar-a-Lago gate today. The bond and the appeals process are still holding the enforcement stay in place. But the legal machinery, the judgment filings, the docketed liens, the court documents listing properties, the interest clock running is documented and real. And it is moving toward the specific enforcement endpoint that the headlines are describing. The homestead wrinkle, that 1993 decision that may have inadvertently created the legal opening creditors' need to reach Trump's most famous property, is the specific historical irony at the heart of this entire story. It is what makes the Mar-a-Lago seizure scenario so specifically explosive and so legally grounded. The appeals proceedings are active, the bond situation is being watched, and we are going to be right here covering every single development as it unfolds. Drop a comment below and let me know what you think. Does that 1993 club reclassification ultimately cost Trump the homestead protection on Mar-a-Lago? Or does the court find a way to preserve the exemption? I want to hear your take.